The Divorce Education Series presented by Findling Law. I'm Daniel Findling, and in this topic we're going to talk about moving with your children, changing domicile. Let's get started. All right, so let's define the problem. What is it that we're talking about? And really, Michigan law is the problem. It specifically prohibits moving with your children under certain situations. Now, it's important to understand that moving with your children means exactly that, moving. If you're going on vacation, you don't need to worry about the law, provided that where you're going is a signature on the International Child Abduction Statute under the Hague Convention. So maybe traveling to Yemen might be a problem because they're not a signature on the Hague. But if you're going to Europe with your children or Cedar Point, this is not going to apply. There is no prohibition under Michigan law that prevents you from traveling with your children. We're really talking about moving with your child. All right, so what do the laws say? Well, we have two laws that we're really worried about, the 100-mile rule and a court rule, that's 722.31 of Michigan compiled laws, prohibits you from moving with your children more than 100 radio miles from its current residence. So wherever the residence was when the judgment of divorce or the custody order is in effect, as the crow flies, 100 radio miles. The second rule is a court rule, and that court rule specifically prohibits you moving with the children or the child outside of the state of Michigan. Now, if you're in a border state, you say, well, wait a minute, the 100-mile rule applies, and I'm living in Michigan City. That means I can go to Indiana or Chicago. The answer is no. Both rules apply. Not only must you comply with within 100 radio miles of your current residence, you must also comply with staying within the state of Michigan. So let's talk about the answer to the problem, the solution, all right? You must obtain consent. You must get the other parent to say it's okay or court approval. Now, really, that or maybe should be an and that's because we have the two laws. The first law is a statutory law about the 100-mile rule. The second law is the court rule that says you must get court approval even if you have consent. Technically, consent still requires court approval. That's the point I'm trying to make. But if the other party's consenting, from a practical standpoint, the court's not going to say no. You're going to be able to move with the child. But really, this webinar is about if a party does not consent. Well, you have to go to court. You file a motion called the change of domicile, which is another way of saying change of residence. And what 722.31 says, we're going to put these factors on the screen right now. First one is whether or not this change of residence is going to improve your life. Not only your life, but also the life of the child. So if moving is going to improve the quality of your life and the quality of life of the child, the court's going to weigh that in favor of the move. If it's not, the court's going to weigh that against the move. All right, whether or not there's compliance. Let's say that you have a parent who is never exercising parenting time, yet now, because they're a controlling nature, they're saying, we're not going to permit this move. I'm not going to give your consent. Well, if that's the situation, what this factor really relies upon is history. Whether or not this is being used to sort of frustrate parenting time, to maybe prevent mom or dad from seeing the child. That's why you're moving. Or you've never seen the child, and now you're making a ruse about it. The court's going to give weight to this notion. All right? That's factor 3, 4, and 5. And here are factors 3, 4, and 5 for us. All right. If the resident change is approved, can the court and the parties fashion a parenting time schedule that's going to preserve the relationship between the parents? If you're moving to California from Michigan, how often is the other child going to see, or the child going to see mom or dad who's staying back in Michigan? So the court has concern as to how this proposed move is going to affect the relationships with both parents. Whether or not you're doing this to secure a financial advantage. Is this because you want more child support, or you're trying to get less child support? That's a relevant factor. And the fifth and final factor is domestic violence. If domestic violence is involved in the case, then the court's going to highly scrutinize the change of domicile. Why is it being done? Is it a form of domestic violence in and of itself? So these are the factors that the court's going to take into consideration when evaluating a proposed move. Now, it's inevitable that you're going to have questions, and let me try to address some common ones right now. Not every case requires a court hearing. If the parties are able to agree, even though we have this Michigan court rule that says the court must give approval, we can do that by stipulated order and just have the judge sign off on it. But otherwise, if a party is not willing to agree and you want to move with the child, you're going to have to file a motion. That could also give rise to other issues like choice of school issues, and we'll save that for another webinar. Now, it's inevitable that you have questions. This is a complex area of the law, and I gave you the law as it's written. For more interpretation or how the facts may apply to your situation, call me. The number's on the screen. Email me. I provided you my email address. Of course, you can always visit us at thedivorceguy.com or divorceforum.com. Thank you and have a great day.